everybody. Thanks for joining us. My name is Ethan Bronner. I'm the National Legal Affairs Correspondent for the New York Times, which, as it happens, means I know a lot less about law than you do, but we'll get to that another time. And I've been asked to moderate tonight's session. So welcome. This is the University of Pennsylvania Law School, the Penn New York Seminar Series. And the goal of this series is to provide a neutral forum to explore and debate some of the pressing issues in law and public affairs, with an emphasis on bringing research and good minds to bear on these topics. So tonight we're going to take a look at the legal and public policy implications of mounting threats to personal privacy, proprietary business information, and the state secrets in the rapidly evolving world of cyber technology. We have two terrific experts with us tonight who we hope will shed some light on these complex topics, and if they don't, we will be upset with them. There are a lot of things going on in this area. You know, on a personal level, you have the relief of the question of how people value their privacy, whether we have the privacy laws that we need. And there's a lot in the papers all the time about it right now: cyber attacks, individual hackers, so forth. Government, the Times just this week, and the U.S. government just this week alleged that the Chinese military is linked to sustained cyber attacks against the U.S., as well as against other organizations and companies and governments. And today, on the front page of the paper, there was a story saying that the Obama administration is expected to overhaul surveillance laws to make internet communication easier to wiretap. Also on another front, a couple of weeks ago, we saw the market disruption after a bogus tweet went out from the AP Twitter account, which had been hacked and said the White House had been attacked. So obviously it was a fabrication, but the Dow dropped more than 100 points. So the stakes in these issues are clearly very high. It's kind of every week, every month, you have a sense that the world of cyber technology is getting out of whack, and you know, we're so reliant on it, and that's why. Okay, so we'll get straight to our panelists. On my right is Anita Allen, and her title is the Henry R. Silverman Professor of Law and Professor of Philosophy at Penn Law School. Her latest book from Oxford is called Unpopular Privacy: What Must We Hide? And she's written a bunch of other books on privacy as well, going back to 1988. In fact, in this book, in the preface, she says she started this 10 years ago. So in 2011, she wrote a book called Privacy, Law, and Society. Anita is recognized for her scholarship on legal philosophy, women's rights, and race relations. And in 2010, the president appointed her to the Commission for the Study of Bioethical Issues. And that commission has now been just asked to play a role in examining this whole brain science thing that the administration has launched. What are the ethical issues related to that? And Anita also told me that she was just in Israel for a month of December teaching these issues to Israeli students, and is headed to Japan in a few weeks for 2 months of that. So we're lucky we've got her right here for tonight. On my left is Lisa Sotto. She's the managing partner of Hunton and Williams' New York office and head of their privacy and cybersecurity practice. The National Law Journal named her among the 100 most influential lawyers of this year, and she's been rated the, quote, #1 privacy expert for the past 3 consecutive years by Computer World magazine. She works with her clients in identifying, evaluating, and managing risks associated with privacy and information security practice of companies and third parties. She also advises clients on security breach notification laws, other U.S., state, and federal privacy and data security requirements, and global data protection laws, including those in the EU and Latin America. And finally, Lisa is chair of the U.S. Department of Homeland Security's Data, Privacy, and Integrity Advisory Committee. And I'm also being asked to tell you, in the name of full disclosure, that she is a grad of Penn Law. And it has been written down for me that she is in the fighting class of 1987. So we're in excellent hands tonight. We're going to do it as a conversation. I'm going to ask them to talk about these issues, and then I'll turn it over to you after about a half an hour. So why don't we start? And I think we'll start with Anita. Anita. So if you would, not everybody here is as versed in these issues as you, so maybe you can fly up some 10,000 feet and give us a kind of overview of privacy law right now as it and this is a hugely developing field.
Okay. Everyone got their glass of wine?
Right.
All right, so you go up, and what do you see? Well, you see there are three kind of domains of privacy law, as I like to say. There's the constitutional privacy law, the common law, and the statutory. I think most of the focus these days is on the statutory privacy law. We have more than 10 or 11 major federal privacy statutes with names like HIPAA and FERPA and Gramm-Leach-Blackley, laws that cover financial privacy, medical privacy, children's online privacy, education privacy, driver's license privacy, video privacy. We have a lot of privacy laws, and in fact, that's one theme I think I'd like to kind of make here tonight, is that we have a lot of privacy law already. Then we have, on the state side, we have common law torts, privacy torts, which can help us out for certain kinds of intrusions and invasions. We have state statutes protecting our AIDS information and some of our other health issues. So we have a lot of state and federal law. We have state constitutional law as well. So the short answer to your question is we have a lot of privacy law. It's federal, it's state, it's comprehensive.
Is it recent?
Most of it is 1970 moving forward. A lot of activity in the 2000s. In the 2000s, that's when we got our health privacy statute, our children's online statute, and our major financial privacy statute, the Gramm-Leach-Blackley. But back in the 70s, we had the Privacy Act, we had the Fair Credit Reporting Act, and the Education Privacy Law, way back in the 1970s.
And did those things, do they work in the internet age?
Well, we can talk about that, because you mentioned that the HIPAA statute, the Electronic Communications Privacy Statute, is way out of date, and we can talk about that a little bit later. And then one thing I think that I should emphasize is that we have a very unique approach in the United States that's sometimes described as the crazy quilt approach. You know, in Europe, they have, they aspire to have, anyway, one very large omnibus comprehensive privacy law that applies to all kinds of data collection, all kinds of data sharing. But in the United States, we have this like crazy quilt of, again, 10, 11, 12 different statutes going on at the federal level. We call it the sectoral approach. And there's a debate out there as to whether the sectoral approach of the United States or the omnibus approach of Europe is better. But I think we're doing pretty good. We could do better, but we're doing pretty good.
Maybe you want to talk about that a little bit, Lisa. I mean, what is the difference between this sectoral approach and this omnibus approach?
It's actually a very big issue right now, because I just read recently that there are 92 data protection laws globally. 92 means there are 92 different schemes that apply in many cases to the same sets of data that can reside sometimes in 16 or 62 different places at once. So you have different rules applying to the same data. It's a very, very difficult thing to deal with when you're a company that operates in 200 or so countries. The sectoral regime, as Anita said, is this patchwork quilt of federal and state law, number one, and then more patchiness in that there are laws that apply to different industry sectors like the healthcare sector, the banking sector, and different data types like data from children under the age of 13, the Children's Online Privacy Protection Act. Overseas, and I think I can say uniformly overseas, there are laws that are considered, quote, comprehensive or omnibus data protection laws. And data protection and privacy are the same thing. It's just a different verbiage to describe the same thing. These omnibus laws apply to data in whatever form or format and whatever type of data, as long as the data is personal information. So information that relates to an identifiable individual. So not subject A, but data that can be related back to me. And I'll digress for 1 second on that note. The Federal Trade Commission, which is the primary enforcement arm in this country for privacy, has really sought to extend the definition of personal information to not just information about humans, but also information about devices. So the FTC now is of the mind, is of the view that that IP address and unique device identifier, those are considered pieces of personal information as well, because they can ultimately identify your device and perhaps be routed back to you.
Is that not the case in Europe?
It is the case in Europe. This is a change, though, in the last 1 to 2 years. So So it's
It
been
makes
a big
sense,
debate.
right? I mean, in a certain way, there's nothing more personal than your IP address these days, right? Or do you
No,
disagree?
it doesn't make sense in my house because I have a 5-year-old, a 15-year-old, a 17-year-old, me and my husband, and lots of babysitters and others. So who's being tracked using my IP address on my computer? Anywhere from a 5-year-old to my husband to my 17-year-old. We have very, very different shopping patterns.
Well, what choice would they have if they didn't consider that personal information?
Well, personal information is something that can be, that should be associated with me as a human rather than the shopping habits of my computer.
And so let's say you're right that it doesn't make sense. What should they be considering your IP address?
It's a good question and one that actually hasn't been tackled because it has fallen in the last 2 years right into the category of personal information. And in fact, the FTC has ceased to even engage in this debate. They've essentially
Really?
said, we're done with that. We're now going to even change the category name to call it covered information because we're not going to engage in this debate anymore.
Well, talk to us a little about cloud computing, about the issues of privacy and cybersecurity there, because everything has now moved into the last 3 or 4 years into the cloud. What does that mean?
So I'll separate for you cloud computing and cybersecurity. Let's do one at a time. Cloud computing is fascinating. It's an incredibly fast-growing segment of our economy, and everything is moving toward the cloud. We all use the cloud in one form or another. Dropbox. There's so many different ways we use the cloud. It is a terrific tool. You get economies of scale. It's a distributed model, so data can reside in any jurisdiction at any given time, wherever it's cheaper and wherever the data needs to go to lower the cost of storing data. So there are tremendous benefits, but there are also tremendous risks associated with cloud computing. So you can imagine that a cloud is a treasure trove for criminals. There's so much data stored in the cloud that if there were a security issue, it could be potentially devastating. So security issues are deeply troubling in the cloud context. There are other issues in the cloud context. For example, in the EU, there are requirements that you not move personal data, you not transfer personal data to a jurisdiction that doesn't have, quote unquote, adequate data protection laws in place. We are not considered adequate in the US. We are not considered to have adequate laws in place. So data is not permitted to move freely to the US, nor can you access data
That's
from
because
the
we,
US.
in fact, have less strict laws than in Europe?
We have different laws, I would argue, rather than...
We have
you
those
think-
sectoral laws.
Exactly.
I see. And do you think that that's a mistake? I mean, that they're wrong to say that we're less protected here?
I think we have many protections. It's just different. It is a patchwork quilt, as Anita said. It's a little messy and it's a little harder to get your arms around. So from a European perspective, the view is it's not ours. It's not good enough, right? So for whatever that.
Let me ask you a quick technical question. The move to the cloud, has that made it harder to protect? In other words, before we were all in the cloud, we were online, and the move to the cloud, does that make it looser and weirder and harder to protect, or does it come with better cybersecurity?
I think the answer is it depends. If you're entrusting, we're lawyers. If you're entrusting your data to a very reputable cloud host, chances are very good that their security measures are much stronger than any security measures we as individuals or even smaller companies could put in place. There are some cloud providers that probably do not have the same types of protections.
But the problem that I see there is that most of us who use the cloud don't have a clue as to what level of protection the data that we're uploading, So when I put stuff in Dropbox, I don't know that that Dropbox isn't then somehow data mining my data and then marketing my information to third parties. Consumers are very, sort of blind as to what actually happens with the data. So it may well be more secure, but there are some consumer protection issues, I think.
So let's talk about that. Can Dropbox do that?
Can they do it?
I don't mean, obviously, it sounds like technically they can do it, but are they permitted to legally?
Well, I mean, I'm sure Lisa has a lot of thoughts about this. I mean, for the most part, those relationships are governed by contract. So
Right.
I decide to use Dropbox. We agree.
Right.
But as you know, most consumers don't read the fine print.
Right.
So
So
we
what
don't
does it
know
say,
what we've
typically?
agreed to, you know.
Do you know what it typically says? Does it typically say you're screwed?
No, it does not. It does not. I mean, the more serious issues are, say, if you're uploading medical information, you're a hospital system,
Right.
you're entrusting medical information to the cloud. Does HIPAA apply? I think the general thought is yes, HIPAA does apply. If it's education data, does FERPA apply? The thought is yes, FERPA applies. But there's a lot of vagueness and a lot of lack of legal clarity around what happens beyond the contract when we entrust data to the cloud.
I mean, there's such an important distinction between a business that's or your health issues in those, or you're just fooling around on the internet, right? I mean, there is people, it does seem, have less interest in privacy than one might have expected in certain circumstances, right? The young people, all the stuff they put on the internet, right? Does it surprise you that there's a kind of cavalier attitude toward exposing yourself effectively online?
Well, you know, technology is enthralling. You know, it's made our lives so much easier in so many ways. You know, the old folks in my family were all on Facebook. You know, that's how we exchange information about the Thanksgiving dinner and so forth. We're all there because it's convenient and it's good. But at the same time, there does seem to be kind of a loss of a taste for privacy, or it's become a lower priority. It's lower in priority compared to the convenience of Facebook, the internet in general, and so forth. So I think we are at a point where we need to kind of step back and ask ourselves, have we gone too far in sharing data? Are we now too willing to share data? Are we too willing to share data without a clear idea of exactly what the implications of sharing are for our reputation, for our for marketing and so forth? So you know, this is a big.
It's a hugely interesting topic.
Yeah.
Do you have a view on this, Lisa? I mean, really, because the question is, what is the risk? What is it that you're risking in discussing how you make cranberry sauce, right? I mean, what are you worried about, right? That's
poisoning somebody? I don't know.
Yeah.
In my case, no. I mean, so it's not the turkey, it's not the cranberry.
Right.
It's the reputation, right? So if for some of us, when we're tweeting, if we're Congressman Weiner and we're tweeting, pornographic, semi-pornographic pictures, we have reputational concerns. A lot of us have sensitive political views that we don't want to share with the world at large. So it matters to us if someone's doing browser tracking. We don't want them to know exactly what websites we visited. I mean, the ACLU is a huge problem with browser tracking.
Would you? I mean, I suspect, I don't know how you feel, that to some extent, the having it all out there is also adding to a general sense of tolerance in the society. That is to say, more people are aware that people are weirder than they thought they were, and that therefore it is giving them a sense of acceptance of various lifestyles, for example. Is that possible?
Then why are people losing clerkships and jobs because of what they posted on their Facebook page? And why are people being asked
I'm not
to
saying
leave
it's all
Congress?
unidirectional. No, that's a fair point. But do you think I'm making a point?
I think your point is a good one, that in fact, I think we are becoming more tolerant because we now understand the greater variety and diversity of human life in our country. But many employers and schools, churches are using information that can be readily found through Googling people or through Facebook to say, well, we don't want you're not the kind of person we want to work at our law firm. We don't want you can't clerk in my chambers.
Happening?
Well, one of the things that's very interesting about privacy, and we love practicing in this arena for so many reasons, but one of the really fascinating reasons is that privacy is culturally based. So the definition of privacy in Indonesia is very different from the definition of privacy in the United States. And I'm told by my Chinese colleagues that the word for privacy in China, there is no word for privacy in China.
Have you noticed there's no word for anything in China?
Right. So you put two words together, and it is pejorative. And it essentially means you're trying to keep something secret. So it's very interesting to try to practice in an area where there are nascent laws. We really have no earthly idea what the legal regime will look like in 10 or 20 years here. Plus, we have cultural norms that differ from jurisdiction to jurisdiction. So what privacy means to me is very different from what privacy means to somebody in a different country, and it's very different from what privacy means to my teenage daughters, who think that everything can be shared with their 5,000 friends, but they're horrified when I try to friend them.
Anita, in the book that you just recently published, there's a chapter, at least a section, I can't remember if it's a whole chapter, on racial privacy, which I found to be a very interesting concept, and I wanted you to talk about it for a few minutes.
Racial privacy. So I was very interested in a California initiative back in the early 2000s. A group of Californians decided they wanted to change the California Constitution to make it unlawful to collect any information about race in California. So public authorities could not collect any information about race. Now, that might look like a good thing, because after all, why is race important? Why should the government know whether we're black or white or Native American or Jewish or Christian? Why should any kind of racial or demographic information, ethnic information, be collected by the state? But the bad thing about this so-called racial privacy initiative, from my point of view, is that it seemed to be motivated by a very specific objective, which was to eliminate affirmative action from California.
Exactly.
And
just to interrupt you, the idea is that if you do collect data about race, then you can use the information, right? And so what the goal of those who fought it was to say, we shouldn't be even discussing it. We want a race-blind, neutral society, right? And your answer might be, but it's a very nice idea, but we're not there, and we need these data to help us get there, so we'd like to still collect them.
Right. So
is there a gap?
So one argument that I made in the book was that I think we still need to collect race and ethnic data for a variety of reasons having to do with housing equality and health disparity remedies and so forth. So I'm in favor for now collecting some race-based information. I also thought it was kind of weird to think about race being, what's my race? Is it private? Can anybody?
Right, exactly.
You can't tell I'm black, right?
Right.
So race is in the face, right?
Right.
And we use the concept of race to refer to some rather common phenotypical characteristics. So to have it made illegal for the government to use race data is a little bit bizarre, because it's so hard to keep this information secret anyway.
Interestingly, in Europe, race and
ethnicity
is an element of sensitive data, which means that you cannot use ethnicity other than with affirmative opt-in consent. And a photo could, in fact, require opt-in consent for use, like on a corporate website when you're showing photos of individuals, because they could show race, as Anita said. The backdrop in Europe is fascinating and really plays into what you're talking about, because European data protection law is so different from that in the US because of the backdrop there, the historical backdrop of using data to persecute, using data, the Nazi regimes using data, Vichy, for example, and Germany, and then also the Eastern European regimes, where dossiers were collected about people and used to kill them. Here, we think of data as a consumer protection, of privacy as a consumer protection right. There, they think of privacy as a fundamental human right. And those words are actually written into the preamble of the Data Protection Directive in Europe. So it's very important to understand the backdrop of the law there, the historical genesis. And this, I think, goes a long way toward explaining why ethnicity is considered an element of sensitive data in Europe, where here, in fact, we share that data commonly.
And for the census, federal census, we are all asked to classify ourselves in accordance with one of 4 or 5 government-defined categories. Some people find that task very offensive. Other people think it's just a bureaucratic requirement. It's not a moment to identify yourself for real. It's just some information the government needs to know. What social categories are you identified with, or do you identify with, for purposes of a certain kind of
And that's not the case in Europe? They don't do censuses in which they ask people their race?
Well, it's not permitted to ask, and you can see why, because those lists that were collated in Europe were used to round up whole communities, and that is absolutely forbidden now.
In all of those countries, not just in Germany?
In the 27 EU member states.
Fascinating.
Mm-hmm. Plus the EEA nations.
Yeah, there are
so
other interesting differences. So trade union membership is considered a sensitive privacy matter in Europe, whereas in the United States, we don't think it's a private matter that someone belongs to a union. In fact, sometimes you wear a button, it's a point of pride. So there are these cultural differences having to do with different histories. We have a history of racial genocide and racial prejudice in this country, but we haven't overall come to believe that it's better, therefore, to not know. We think that knowing helps to address the problems better than not knowing.
And you also talk in your book about the right to be forgotten.
Yes.
Talk about that for a minute.
This is very important. Right? So Google is this history. You will never be able to be forgotten. And a lot of people, both in the US and abroad, are talking about the idea of a human right to be forgotten, which is basically the idea that at some point, facts about us should be left to the dustbin of history, right, and not so easily retrievable. So maybe some of the information that we're generating with our social media, with our cell phones and so forth, should be at some point deleted, as it were, literally erased, deleted, and they're in that sense forgotten. I do think that the world was a little bit more comfortable when we knew that we could count on our friends and our relatives and our communities literally forgetting things about us that were not so favorable. But now, you just type in the name, and then all that history of embarrassing, events comes up again.
Well, your stuff's embarrassing. I'm fine.
I'm so glad I was pre-Facebook. But
Ethan, that's an important point because, in fact, we're pretty. Most of us in this room are sort of in the middle of social norms, But folks who are on the edge really are at risk.
Yeah,
so
of course.
It's
and actually, apparently, after you die, it's not clear how you can erase.
So legally, the question should be: should we have laws that require the non-retention of data? And as far as I know, Lisa, only one of our federal statutes contains a provision requiring that data be deleted, and that's the video privacy law. So when you go to Netflix or Blockbuster, there's a right you have by statute to have the movies that you watched, that information deleted at some point. Only nowadays, the companies are claiming a business reason to keep the data beyond the year or two they used to keep it when it was all offline.
Yeah, it's a laudable concept. The problem is how in the world do you operationalize this?
Yeah.
Because data is propagated, it's disseminated in so many different ways.
Right.
And if I post something about Anita, why is it Anita's right to then be able to delete that data? And who's to say whether it's accurate or inaccurate? So it's a very, very tough issue. I think it's probably not possible to really operationalize it.
You can't just say, okay, all data that's 10 years old should be deleted.
Yeah.
It needs to be more selective than that. Yet how do you choose what gets deleted?
Yeah.
What you could do, though, was to have rules that required that consumers have the right to request that data that they have posted or they have uploaded be at some point.
But you have to remember to do it. Yeah, I mean.
And if it hasn't been disseminated, and if it hasn't been used in some way,
and if you then die.
And this concept is built into what is a new rule in Europe that's going to come into place in about 2 years, the EU Data Protection Regulation, which will take the place of the directive. But the right to be forgotten is built in, and there's enormous struggle right now in figuring out what that really means and how do you really put your arms around that and put rules around that.
I mean, America's all about second chances, right? And you can't have a second chance. Maybe Congressman Weiner will have a second chance.
Well, it looks like he's
up to you, the voters of New York, to determine.
That goes back to my point that it turns out we're all weirdos, so it's okay. I wanted to ask you, Lisa, also about what happened in Boston, because in a certain way, all of was a very, very public event, obviously the marathon bombings, but the fact that there were so many photographs, so many pictures, so many cameras meant that within a very short time, we as a society were able to zero in on the guys who did this. And it was very comforting in many ways. On the other hand, of course, it's sort of scary to have everyone being photographed all the time. And the other thing that has happened is this question of, whether the brother who died, Tamerlan Tsarnaev, he had apparently expressed radical thoughts at the local mosque in Cambridge. But the administration had stopped monitoring mosques. They decided it was inappropriate. So there was some talk of, my God, we should in fact be in those mosques. I'm not in any way advocating it, but do you think that racial profiling in the name of counterterrorism is crazy?
Well, there is no mistaking the fact that we live in a surveillance society, and we live in the information age. So we live in the age of big data. We've all read about big data, this fantastic little buzz term.
Yeah, it's a great phrase.
It's a great phrase. The fact is that the volume of data about us and the sources of data are so voluminous and distinctive. We have cameras everywhere. You can be tracked by your cell phone. You can be tracked with your card key, with your when you pay a toll. There are so many different ways of tracking us. You put all this together and you can form this incredible profile of what we're doing just about all the time, every day. With respect to the marathon, I think what we're seeing is that in some instances, depending on context, security is deemed by the populace to trump privacy.
Right.
And then in other times, when things are quiet, privacy is deemed to trump security. I think the general sentiment with respect to the Boston Marathon was, we want to go after these guys, and if we need to use facial recognition, which is a really scary concept, to do that, we should do it. And if we need to do profiling to do it, we should do it. So I think, I think in that instance, we saw a circumstance where there was a real sentiment in favor of profiling and subsuming privacy to security. But I don't think that's always the case.
Does it bother you?
Well, I don't think Boston was about racial profiling. I mean, one of my students is here from my privacy law class, and before the terrorists were apprehended, we had a conversation in class about what technologies would be used to apprehend the terrorists. And we got them all, the cell phones, the video cameras, the thermal imaging. We literally talked about every single one of those technologies the day before they were all deployed to catch the terrorists, because it's obvious what kinds of resources we now have to track people down. But I think in the future, the problem is that now we know the ethnicity of the Boston bombers. Now, for a period of time, anybody who's a Chechen in America or a Muslim will be under additional scrutiny. And
inappropriately, in your view?
Well, I think inappropriately to scrutinize an entire. There are over 1 million people in the United States who practice Islam. You're going to surveil all of them. You're going to go to Dearborn and set up so we can't do that. We can't do that and still respect civil liberties. We need to be more specific. So maybe we should be focusing on why was it that when there was some suspicion shined on this particular individual that we didn't quite get it, that our interviewing process didn't pull out the radicalism of this individual, what he was capable of doing.
And it may just be a failure in law enforcement there.
Yes.
I'm curious, when you were spent your month in Israel, did this kind of issue come up? Because there really is very distinct racial profiling at the airport in Israel.
Yes.
And I'm wondering, when you taught law students, whether this issue came up.
Yes, my Israeli law students, I had about 80 of them, they were to a number quite persuaded that ethnic and racial profiling was appropriate. And the people of Israel are mindful of the look of people around them. They know who's Arab, they know who's Jewish, they know who's Ashkenazi, they know who's Sephardic. They're very good at seeing these I don't even see it, but they see it. And they know that if you see an 18-year-old Arab-looking kid getting on a bus, that's a moment to be, to have the radar go off, and it might be a terror. And they catch people that way. They actually do.
Well, that's of course true.
It's true, yeah. So but the segregation of Israel makes that possible because there's so few Arabs who you might see in certain parts of Tel Aviv or Israel that when you do, it does. But I'm very personally troubled by that.
I understand.
That we've come to that point where
of course
the level of distrust and the level of friction and war is so great that we have to feel compelled to use racial profiling.
Lisa, are there privacy law success stories that you want to share with us? Has it gone especially, are there certain things that have gone especially well in your view?
Yeah, well, there are more people on the do not call list than there are registered voters in the United States.
Right, we'll have a separate session in an hour about the failures of our electoral system.
That's it.
But you know what, Lisa? I asked my students, who are mostly under 30, how many of them had a landline home telephone? It's like, nobody.
Nobody anymore.
So I love Do Not Call. It is a success story, but it serves the needs of a certain population at this point more than another.
No,
but it's definitely a good one.
I think one of the areas that we're really struggling right now to manage is cybersecurity. So I would say this is an area that we have not gotten our arms around. We are dealing with multiple threat actors. We're dealing with nation states in activities that are known as advanced persistent threats. We're dealing with hacktivists, who are essentially anarchists seeking to disrupt society, and we're dealing with traditional hackers, the folks who just hack into systems for financial gain, either stealing identities to commit identity theft or account fraud, or stealing intellectual property, for example. So when you're dealing with those kinds of multivariated threat actors, we really need a legal regime to deal with this. And we have failed so far to pass a law to manage this really significant problem. And we mentioned the Chinese threat earlier. So this is an area where Congress has failed, and the President has issued an executive order in response. The executive order requires that government agencies devise a cybersecurity framework during the course of 1 year. So this will come into place in January, February of 2014. So here, Congress has not been able to get its act together. We're still hoping that Congress will get its act together, and there's a bill that's been proposed now several times, CISPA, that would allow for information sharing as between the government and private parties, and would provide immunity to the private sector if the private sector shares information with the government, and that information may have, for example, personal information of individuals. So this is an area where I think we have failed to move as quickly as we need to move.
Do you think that what we're accusing China of doing is really a cyber attack, or is it more of a kind of cyber exploration? And do you suspect that the United States is doing the same thing to them?
It's espionage through a different means, right?
But
We've been
are we
doing
doing it
espionage
too?
forever. Of course we're doing it. Of course we're doing it. Every self-respecting nation is doing it, and needs to do it. It's the new method of spying. So yes, of course we're doing it.
So what are we so offended about?
Well, here's the question: are we sponsoring in this country? And I would venture to guess we're not. Hackers whose job it is from 9 o'clock in the morning till 6 p.m. at night, who sit in a room to go into private companies to steal intellectual property or research and development, so that they could be 10 years ahead in the R&D cycle in 1 minute, because they've stolen all of that R&D. I do not believe that the United States is doing that.
You don't. It's nice that they limit their hours, by the way.
You can see it. You can see it.
Right?
Decent labor laws.
You can see it. You can see when you look at the logs, you can see that they come on 9 o'clock in the morning,
really?
China time, and they leave 6 o'clock. They're out the door.
That's great. Anita, how are law schools like Penn training? I see you're teaching a course, the next generation of privacy and data protection savvy lawyers.
Well, I'm proud to say that Penn is one of the few law schools that has a comprehensive data protection and privacy course option. I'm one of 3 scholars who have put together comprehensive textbooks in the field. I'm glad to know that some of our graduates are now practicing privacy law in Washington and other places. I think that Lisa was not my student, but there are some who were. So we really, we teach the class, we have events, we have a lot of focus on privacy law at Penn. I think that we could do even more. I think that as the field is expanding, I mean, it used to be that privacy law meant, a little Roe versus Wade and a little Fourth Amendment, and
is that how you first got interested in it?
Absolutely.
Yeah.
But
so
now,
funny, right?
I mean, it's too much for one course, actually. You need a separate cybersecurity course, a separate intellectual property and privacy course, a separate constitutional course, a separate tort law course. There's a lot of law out there, and I'm hoping that as we move forward, we'll have a greater number of people who are willing and able to teach in this area.
This is actually a huge problem, and we talk about it a lot in the profession. There is a requirement in the proposed regulation in Europe that every company with more than 250 employees has to have a data protection officer. There simply aren't enough people educated in this area to have
who know
data
what they're
protection
doing to do it.
officers. That's right. So it's a significant issue. We talk in sort of my generation of privacy professionals, we talk about the fact that there is not a generation behind us that is that in sufficient numbers to manage this information age, and we're trying like the devil to train associates in law firms or junior people in companies to take over in these roles. And law schools are starting to do their part. But as Anita said, there are only a handful, probably fewer than half a dozen law schools who really have full-fledged privacy programs.
Yes, yes. The Practicing Law Institute, which has programs in New York and in California, they have now for almost 10 years, I think, had a privacy law 3-day session where New York lawyers can go and, for CLE credit, study privacy law with experts like Lisa and me. So that's a good thing. So that maybe it's not happening so much in law schools, but law faculty and law graduates are educating that next generation of privacy law.
I mean, it's amazing how
people.
quaint the topic was 40 years ago.
Yes.
Right?
There was no topic 40 years ago.
Well,
so here's
Roe v. Wade.
It's different. It's not data privacy, right?
Right, exactly.
So we have to separate information privacy.
Right.
When I first started teaching law in 1986, I think it was, I used to have a standing request from the library. Send me a copy of all the newspaper articles that mention the word privacy. And I'd get like a little tiny, and I had a shelf in my office for the privacy books. They were like, it was like this many, literally. And now, I need like a Mack truck to bring in every day, every article, which the word privacy was mentioned. There's just been a sea change in the level of public awareness and interest in privacy in just a few decades. It's just stunning.
I started practicing in this area in the year 2000, which was very, very early, and really first mover advantage there. There was almost no one. You could count on one hand the number of private practitioners in this area, and now almost every law firm has somebody who says they practice in this area. So it's really it's just become
exploding.
Yeah, it really is exploding.
I think we're going to turn it to you guys now for some 20 or so minutes. So there are microphones that are available. There's a lady up here in the front. If you just wait for the mic. Wonderful. You're on, ma'am.
Hi, I'm Amy Davis, and I'm a solo practitioner in corporate. You mentioned about Boston. One of the things that I was hearing is the privacy concerns of individuals that were captured in those cell phone photos and videos, and the fact that the law enforcement officers were, soliciting all this information. And, it comes to mind, what about the guy that took off from, well, I guess it was Patriots Day, but assuming that it was a work day, you're now on public film, outside of work, not doing what you're supposed to do, and what about the privacy rights of those individuals?
When I first started in this area, I went to visit a client that was a location-based service and really a data broker. And I walked into the conference room, and he said, I just want you to see, the head of the company said, I want you to see what we do. And he projected onto a screen me and my family and all my neighbors and all of their connections and all my schools. And from that moment on, I had no illusion that anything in my life is private. And that's just the way it is.
But, does that make you want to fight for your privacy more? Or you want to just say, forget it?
And again, I'm mainstream, right? So for me, I really couldn't care less, and of course I don't use Facebook the way my children do. But I do think it's for folks who are not as mainstream, for the Muslim population and others who are more targeted. Then we do have to think very, very hard about these issues.
I was actually a little bit surprised by people's reaction to the, because it's just a fact of life. There are cameras everywhere in major cities. Here in New York, for example, if you go past Times Square South, there are cameras all over the place. Southern Manhattan is just covered with cameras. The cameras are there. There's also license plate monitoring and package delivery monitoring, all this post 9/11 surveillance. So it's a little bit odd to think that people are just kind of figuring out in Boston that when they go outside, they're going to be on camera.
People don't think about it. It's also only about 10 years old, this phenomenon,
Exactly,
right?
yeah.
So,
In England, London
Right,
has
everywhere.
more CCTV than any other place in the
Right.
world.
And we've mimicked that here in New York, where they
Right.
have the whole ring of steel around Southern Manhattan, similar to what we have in London.
other questions? Yes, ma'am. Just 1 second. Wait for in the fourth row there, and the second person in.
Hi, sorry. I'm Ebony.
Modulate, please.
I work in entertainment law at a,
Sorry.
Entertainment law.
but I'm going to law school in the fall, so I'm not a lawyer. I just have a question about, I guess, corporate law, right? For example, we, in terms of privacy and making sure you have the security measures, so say you want to make sure you have the most secure networks. We just had issues with HIPAA, for example, and you have you have a tech team that tests your security to make sure it's as good as possible, I guess. But then you say if you get someone that's too good and they breach that, and so it's what's been brought up. I had a conversation with a colleague recently, and they were saying, well, you kind of want to find someone that's not gonna breach it because you don't know how to get the best security measures so that you're not liable legally if something does come up. So is there a standard, and who should be responsible for creating that standard, I guess?
Yeah, so that's the question that I'm probably asked 3 or 4 times a day by general counsel. What standard is there for security? I'll just follow it. That would be really nice. The problem is the bad guys are so enormously sophisticated and really challenging our ability to keep our systems safe. So the problem with our existing information security personnel is that, and some of them are very, very good, but we tend to fight yesterday's battle. And we need to figure out what tomorrow's battle is, but we don't know it until our system's been breached. So it's a very difficult problem. This cybersecurity framework that the executive order has mandated hopefully will give us some rules of the road, but I will tell you it will, by its nature, be amorphous and vague. It has to be. You can't dictate 256-bit encryption because tomorrow there's going to be a more sophisticated encryption level. So it needs to be vague enough so that you're not tying the hands of your information security personnel so that they can keep up on all of the threats, which change daily. In my firm, we've handled well over 900 data breaches. And I will tell you that almost every day I'm surprised at the new one that comes in the door. There's something new and unique about it that I've never seen before. So it's fascinating to practice in this area for that reason, but it's also a little bit scary.
Other questions? Sir in the back. Just wait for the mic. Right across from you. Right across from you. There he is, right there. Raise your hand, sir. Good, thank you.
Hi, I'm Barry Belgrade. I'm a Penn-trained ophthalmologist here in New York. And one of the older statutes for privacy is HIPAA. And we deal with that in the medical profession all the time. And there are 2 primary approaches to HIPAA. There's the strict enforcement that one finds on the parts of institutions, such as third-party payers and hospitals. And then there are the more lax applications of HIPAA on the part of the individual practitioners that are responsible for the actual data. In general, it's rather frustrating to come up against HIPAA when you're trying to get information that could help treat a patient. If anyone's ever tried to talk to an insurance company over the phone, I'm sure everyone in this room has had that sort of an experience where they run into a brick wall. How do we modulate the access to records, which now there's a huge governmental push to make electronic, yet maintain confidentiality and privilege?
The HIPAA standard is probably the closest we have in this country to the European regime. And it contains some of the same rights that Europeans have, like a right to access data, a right to correct incorrect data, a right to understand to whom your data has been disclosed. So there are a lot of rights built into HIPAA that are found in more stringent data protection regimes. So you talked about lax application and more stringent application. There's only one standard. It's that some folks are doing it right, some folks are doing it wrong. And one of the biggest problems with HIPAA that I see is that there is a tendency, there's a misunderstanding about HIPAA, so there's a tendency to overreach. Because people are so afraid of disclosing data that they're not sure whether they can or cannot disclose, that they just hold it close to the vest. But you know, the bottom line is you can disclose data for treatment, payment, and healthcare operations, period. You can do that. But there is so much misunderstanding that many healthcare entities don't do it.
It's too easy for clinicians and for staff at hospitals to violate HIPAA. And you really need to have a combination of professional ethics combined with a respect for the letter of HIPAA in order to get the right outcome. A lot of doctors, I love doctors, they saved my life more than once, but doctors are a little bit arrogant. HIPAA is for the little people, not for them. It slows them down. They want to be able to share more quickly and without having to go through all the formalities of HIPAA, and they do it all the time. So I like to, to talk about, when I talk about health confidentiality, to talk about the need to marry strong professional ethics with respect for the law.
And that's a great point. When we think about the law in this area, we think, well, when we think about practicing in this area, we think about the law, we think about ethical standards, we think about the 50,000-foot view so that we don't hit buildings as we're flying, because as we move from jurisdiction to jurisdiction, we will hit buildings. So we really have to rise above, and that means taking an ethical approach to privacy. So something that we ask each other all the time in my practice is, what would your mother think? And if your mother wouldn't like a practice, then we tend to shy away from it.
That's interesting. Other questions? Just one second. There's in the second row here, please.
Hi, I'm Renisha Smith-Duke. I'm an in-house counsel at an entertainment company. And you mentioned that the FTC now considers IP addresses as personally identifiable information. And I'm wondering if there is a consistent standard with respect to the various laws that apply to the collection and distribution of PI. And I'm thinking specifically about COPA, the point that you raised, that there's an IP address. If multiple members in a household use that IP address, what do companies that collect this information, what standard do we follow when we're thinking about what level of compliance and privacy laws we have to follow when collecting IP address or browser tracking and things like that?
One thing that's really maddening about US law is that we do not have a standard definition of personal information. So in Europe, there is one definition for personal data, and we know exactly what it means. In the US, we have literally hundreds of laws that define the term differently, and we don't even have a term. We call it personal information, personal data, personally identifiable information, personal identifying information. There's so many different ways of describing this same category of data. The answer is no, we do not have a uniform standard here, and that's the criticism of our patchwork quilt, which is born of our of federalism. We have state laws, we have federal laws, and these laws have grown up. So Anita mentioned the Privacy Act of 1974, which was essentially the first privacy law in this country, which was enacted to curtail some of the government's uses, federal government's uses of data, and it arose in the wake of Watergate. So We have grown up, our society has grown up to put in place a financial privacy law, to put in place a healthcare privacy law, to put in place a law that governs children's data for children under the age of 13. But because of that patchiness, that morass, really, we don't have a uniform standard.
On this IP address issue, I have a slightly different perspective than Lisa, because there have been a number of cases where people have committed defamation or invasions of privacy or infliction of emotional distress or other heinous activity, hiding behind the anonymity of the internet. And only by courts being willing to force internet service providers to reveal the identity of the person behind the IP address have we been able to get people who need to be sued or prosecuted, sued and prosecuted. And I think you're right that your IP address is one which is associated with like 7 or 8 people. But if there were, you know, I don't mean to offend you, but if there were a child pornographer in your household, identifying those 5 or 6, 7 people would make us closer to finding the heinous person that needs to be put in jail. So it's not perfect, but it's we need to. I think we need to. Yeah.
I wanted to ask you also. I don't know how you feel with regard to the. I mean, one of the things about federalism is that this 1,000 flowers bloom. It's an experiment in many ways. It's a great thing that we don't have a single standard in this country, right? It allows us to experiment. But does that work with this stuff, or is it just make it more of a mess?
It's difficult. I think it is difficult. I would predict, but I've been predicting for years, the same prediction in 5 years. And this, you know, the 5 years keeps extending.
Right.
One day I'll be right.
Yeah.
We will have an omnibus privacy law in this country. I think we're headed in that direction, but it's a very, very difficult thing to pass.
I mean, it makes it hard for lawyers, obviously, but
well, yeah, but that's good for us. Right?
That's true. You make money.
We were headed toward an internet privacy law before 9/11. The FTC had published a report advocating such a law, and the moment 9/11 happened, that conversation dropped. The head of the FTC, Mr. Morris, made an about-face and said, well, we're not going to pass any new privacy laws. We'll enforce the ones we've got, COPA, Graham-Leach, but we're not going to have any new internet privacy laws. And that was a very revealing moment that the movement toward privacy seemed to conflict with the demands of national security post 9/11, and we haven't completely recovered from that, in my view.
We haven't. Yeah, just to give you a sense of the patchiness, we have 46 state data breach notification laws plus 4 jurisdictions: Guam, the U.S. Virgin Islands, D.C., and Puerto Rico. So that makes 50 different laws that have different standards about when you need to notify somebody whose information may have been compromised.
Wow.
How do you deal with that?
It's a mess.
Do you have a question here? It's a gentleman up here. Just 1 second for the mic, please.
So as someone that's coming not from the law side but from the cybersecurity side, it feels like there's an issue that we've been dancing around here, which is one of balance between exposure of information on one side, with things like increasing the communication among federal agencies from CISPA and things like that are being proposed, versus privacy that is entitled. If you move all those things together, you get to this very difficult, problematic place. If you get all that information into the hands of federal agencies, if you get it to the place where it is now in the hands of corporations that don't have the privacy requirements that individuals do, you get to a very problematic place. And that seems like a place that's really out of this idea of balance, of balancing what people actually need to protect their information, to keep themselves safe, versus what the federal government needs to do to protect critical infrastructure, which is something that's been coming up, for instance, with the attacks on South Korea recently. And it feels like we haven't actually been talking quite to that point yet. And I was wondering if either Anita or Lisa had some comments on that.
Well, I think we are starting to talk to that point. I don't think it's ideal, but for example, the committee that I chair at DHS is the Privacy Committee. We work very closely. We work for the Chief Privacy Officer in the Privacy Office, and that office is there to make sure that that balance is not thrown out of whack. The other point that I would make is that in the executive order on cybersecurity, on page 2, I think it was, there is a provision that requires the government to consider privacy and civil liberties in creating its cybersecurity framework. So there is real consideration given to these issues. Now, we'll see how they play out over time, but again, this is a new area, and we're just feeling our oats.
I guess I feel that balance is often in the eye of the beholder, you know? I mean, it's a very attractive idea. Let's be balanced. Let's be sort of in that middle. But to actually operationalize what that means in particular context can be very difficult. And two people who studied the same problem, the same cybersecurity issue, may feel that different policies achieve that ideal balance. So I love the word, but at the same time, I think the word is sometimes just not going to get us to necessarily to the optimal place.
This is where the ethics issue comes into play. You know, we have to look at the ethical issue of particular situations. The devil's in the details, so we really can't think about broad generalities, I think, in this area.
You want to follow up for Sec? Sure.
So there's a specific point on the ethics and whatnot, and we've talked a bit this evening about profiling and whether it would have been appropriate to profile the Muslim communities in Boston, for instance. And that seems to be exactly very pointed if you think about, okay, in hindsight, that makes a lot of sense. But before the Boston bombing had happened, would that have been an appropriate action to take? Would the reaction to, say, the proposals to build Muslim community centers near 9/11, is that entirely appropriate for the kind of country that America is trying to be?
Unanswerable.
Unanswerable, and you know, we have to be fair to different ethnic groups. I mean, a lot of people have committed acts of terror who are not Muslims, and we don't, you know, surveil all the white people because someone, you know, bombs the Oklahoma Federal Building, you know.
Right.
So we have to be careful when we're tempted to think that somehow, if we can name a minority, we can surveil that minority. We wouldn't take that approach if the person who was a terrorist was a member of a majority group. So I just worry about that, going that direction. And you know, they say hindsight is 20/20, right? And that little maxim is true. We have to look at these things, I think, from the point of view of not hindsight, but of foresight. From a foresight point of view, what sort of First Amendment free democratic country do we want to live in? And I think we don't want to live in the world in which different communities are under surveillance because some one or two people in that group committed acts of terror.
But don't you think, Anita, if on September 11th, 2001, if there had been an October 15th and a November 7th, in other words, if this had continued, your argument would not have held much sway. But actually, it turned
additional attacks that occurred.
I mean, and in fact, on that day, I remember thinking distinctly, this clearly is there's something big coming, and it didn't come, right? I mean, the most interesting to me is that there really isn't that much terrorism in America and really in much of the world. So the question is, what are appropriate precautions to take given the scale? But if the scale were bigger,
well, sure,
it's much
change
tougher.
the facts and we change the needs.
And I'm not to say that Israel's got it right by any means, but they, for their needs, think they've got to be a much higher vigilance than we do.
Right, but you know, a very different country.
Very
right?
different
they
country.
make all their 18-year-olds join the army.
They do.
We don't. So it's a very, very different situation.
Absolutely. Other questions? We'll do a few more minutes and then we'll wrap it up. Sir. I'm sorry. And then we'll go to you. Sorry. Just wait for the mic. Yeah.
I'm Jason Kedover. I actually just graduated from Penn last year, and I'm an aspiring law student. We heard Eric Schmidt at Google this week talk about establishing essentially the equivalent for juveniles of expunging your digital record by creating a delete button when you turn 18. But one thing that comes to mind immediately is the concept of self-censorship, and to what degree that has to play a role in everything that goes on the internet. I mean, clearly Anthony Weiner may be a different person, and everyone may be weird or have their own unique personality. But if Anthony Weiner puts a picture out there that deserves to be out there because he chose to do it and was irresponsible enough to do so, So to what degree does self-censorship play a role in all of what we're talking about here?
This is a great question because my current project is a project all about what I call the duty to protect your own privacy. And I wish you were, because we're on the same wavelength. I think that a very big missing part of the conversation for the last 10 years has been, what are my obligations as an individual to protect my own privacy? Now, I can't control what Google does, and I can't control what Facebook does, but I can control what I do. And I do think there's an ethical obligation to be vigilant for the sake of my reputation and my dignity and a whole bunch of other values.
Do our institutions owe us to learn how to do that?
Exactly. And I think that we should create a new model in which we see the government and the private sector as partners in our ethical goodness. They need privacy policies to help us do a better job of protecting our own privacy.
We'll just take 2 more questions. Sir, you had one?
Well, my question is to Esquire Sotto, and actually it's a very basic one. You alluded that there is no consensus as to what private personal privacy is. So what constitutes personal privacy under the law of the land? I mean, whether that's statutory or...
I'll answer it in 2 ways. The way I define privacy, information privacy, is to consider the appropriate use of data in context. Okay, so that's what we think about. Given the context that we're faced with at any given time, what is the appropriate use given the reaction from consumers, the reaction from employees with respect to their data at that moment? The legal regime is built around uses and disclosures of data, collection. What data do we collect in the first place? Do we collect data of children under 13, under HIPAA? How do we use that data? To whom do we disclose it? And how do we secure it? That's ultimately what our legal regime is about. It's following the life cycle of data from the point of collection to the point of disposition and everything in between.
I agree with all of that. I'd also add that there are particular phrases and concepts that are used in the law. So for example, in tort law, there's this idea that we want to give people protection against highly offensive invasions of privacy, highly offensive publications, highly offensive intrusions upon seclusion. But yet that notion of highly offensive is one which needs to be somehow cashed out. Its idea of what's appropriate in the context is a way of understanding what it means to say highly offensive to a reasonable person. Similarly, in, say, the Fourth Amendment context, we're looking for expectations of privacy. What are expectations of privacy? And it's, again, it's kind of mushy and vague, and it depends upon cultural understandings of what's appropriate in context. So we're really struggling to give meaning to the idea of privacy based on our cultural values. We don't want to be stuck with our cultural values because some of them may be wrong, but at the same time, they are the foundation for how we look at these issues, and we need to be sort of self-critical as we move forward.
One last question back there, please. Yeah, thank you.
Yeah. Hi. So my question has to do with after there's been a breach. So you
With
have,
what?
we look at in political context. We see Sanford, we see Weiner, we see Spitzer. They all had their own breach, and then there was the cleansing ex post. What was involved in them repairing the reputational risks and reestablishing themselves. Conversely, if you look at corporate America, the security breaches that occur, whether they're inadvertent or whether they're self-induced because of a disgruntled employee, how do you go about quantifying the amount of time, money, and attention that is being dumped into these kinds of breaches in the cleansing operation ex post? How do you go about dealing with this? To me, this is like the big 800-pound gorilla in the
Great
room.
question. So there are phases in a security breach. There's the identification phase where you figure out what happened and what the scope of the issue is, what data has been compromised. Then you respond. You send letters to the individuals whose data was compromised. You notify state regulators. These are the legal responses. Then there's the remediation phase. I think that's what you're talking about, the remediation phase, which is a question of taking a holistic approach, really, to your organization, looking at the technology that you have in place, making sure that there are as few vulnerabilities as possible. There are always vulnerabilities. Making sure that your data governance framework within the company is strong, and that you have appropriate human resources devoted to this area to make sure that there are folks who are accountable for the security of data. We really try to think holistically when we're working with a company that's been attacked, because if you think only about the technology, then you're missing the whole policy framework. If you think only about having the policy framework in place, then you're missing pieces of the technology. And let's not forget about paper data. You know, we think a lot about computerized data, but there's paper data too, and we've had plenty of clients who have seen huge amounts of paper data taken to the dump, and then there are folks who are known as dumpster divers who come and whip those sheets of paper out and then use the data contained in the paper to commit identity theft. So that's why a holistic approach really is critical. And then, of course, this is not one-stop shopping. This is an ongoing issue because the criminals, because technology is so advanced that we can make mistakes and we can send an Excel spreadsheet containing 1 million people's social security numbers to the wrong party, or we can have hackers come into our system, or we can have a rogue employee who's sitting next to you, which happens all the time. We have to think about protecting against all of these vulnerabilities. It's very difficult. How do you quantify? I think there are some studies that have been done to actually quantify the pain in monetary cost. I'm not sure that any of them are particularly accurate in trying to quantify, but the fact is it takes an enormous sum of money to combat these problems.
So on that note, we'll wrap it up. Both of you have been fabulous. Thank you so much, and thanks for the audience. Penn Law, thanks you. Good night.